So thank you, Ben, Josh, Michelle, Eric, Pat, Sherry, for getting on the chat and introducing yourself. We appreciate it. Again, if you're just coming in now, we're going to get started here. So if you could introduce yourself in the chat, who you are, where you're from, what you do, and then one hope or question that you might have for today's session. Otherwise, we are joined today with our friends from Thrun. We have Kelly Bowman and Brian Baaki, both from Thrun Law. They're going to spend the next hour with us, walking us through best practices relating to information requests and FERPA and those types of things. So excited to have them with us today. Before I hand it over, I just want to talk about a couple of procedural items. Number one, we are going to use the Q&A system to pose questions. We're going to actually end up probably holding the questions until the very end of our time here today. So if you want, though, while you are waiting for a question to be answered, you do have the option to upvote, and that'll help us kind of prioritize the questions, especially if we run short on time. So please use the Q&A for questions. The chat will be used to share ideas or comments based on what you're hearing or what others are responding. So again, try to put your questions in the Q&A, not the chat, if you can help it. And then a copy of the slide deck that Kelly and Brian have, as well as this recording of the webinar, will be shared out over the next couple of days. It takes a couple of business days to get that prepped and ready. So you will get a copy of everything you are seeing today. Otherwise, this is just kind of our typical disclaimer slide that we have on here. Because this is being recorded, just be mindful of the fact that information is, we'll say accurate through today, October 28th, 2025, meaning if you find this webinar on our website in a week from now, in a month, and a year from now, know that information may have changed. And obviously anything that is some sort of legal guidance is just guidance. You always want to defer to your own legal counsel before making important decisions. So just be mindful of that. Otherwise, I think that is it for me. So I'm going to stop sharing, and I believe Kelly's going to take over.
All right.
And the show is yours.
All right. Does that look good to you, Ryan?
There you go.
Now it does.
Great.
Yeah, now you're good.
All right. Sounds good. Go ahead, Brian.
Okay, so good morning, everyone. Thank you for being here. I'm going to take the first half of this presentation and talk about FERPA, and then Kelly is our subpoena expert, not just today, but kind of firm-wide. So she's going to take over the second half and talk about subpoenas. We are going to redouble the disclaimer in a moment. I believe that's the next slide. Okay, so these slides reflect general legal standards for the related presentation and are not intended as legal advice for specific situations. We go through a couple hypotheticals, but they're just hypothetical. Every situation is going to have its own facts and is going to have different determining factors. So these are just kind of to make a general point and not to address a specific situation. Future legal developments may affect these topics. Thrun Law Firm does not authorize AI note-taking for this webinar. AI note-taking may be misleading. Let me see here. Ryan, your share thing is covering the slide. This document may not be reproduced or redistributed in whole or in part without the express written permission of Thrun Law Firm. Okay, so I'm going to handle FERPA today. We get a lot of FERPA questions. I would say I knew probably absolutely nothing about FERPA before I got to this firm. It's not something that you learn about in law school. As a student, I think the only thing I knew about FERPA was that professors couldn't put graded work in a box outside their office door because of FERPA. I didn't know if FERPA, if that was a law or a kind of a contagious disease. But working here, all these questions come in and just totally new situations. We have people who've been working here for 20 years. They're stumped by a FERPA question, and then we have to go and look for the answers. The answers are out there. It might take us a minute to get to them. So if you throw me a curveball or a hard slider today, I might not be able to field it, but it's something that we could find the answer to probably within 24 hours. Okay, Kelly, next one. Okay, so again, I think we all have different levels of FERPA knowledge. So not to insult anyone's intelligence if I'm kind of repeating things that you know, but I think it's important that we put the horses before the cart here and get the basics down before we get into the more, I don't know, expert type of information. So FERPA grants students, if 18 or older, and their parents, 3 primary rights. These are the big 3: the right to inspect and review education records, the right to seek amendment of education records believed to be inaccurate. So not so much the right to amend, but the right to seek amendment, and the right to consent to disclosure of personally identifiable information, otherwise known as PII, in education records. Okay, so then this leads to the question, what is an education record? And the FERPA statute defines an education record as those records, files, documents, and other materials which contain information directly related to a student and are maintained by an educational agency or institution or by a person acting for such agency or institution. So that contain information directly related to a student, that's key. I don't have a slide on here about videos, security camera footage, but we get a lot of questions about security camera footage. And I think an easy shorthand for thinking about that, and if it's an education record, is, with a few exceptions, that mainly pertains to actions for which a student is disciplined. So either it contains an image of a student doing something for which they were disciplined, or another student whose education record that video might go in might be, a shorthand would be the victim of that. Okay, so their locker was broken into. They were beaten up by this student. Okay, so that is something that would be in an education record, qualifies an education record, but general, I guess you could call it surveillance footage or bystander footage where other students are just walking by or even just witnessing an event, most likely is not an education record. Okay, and then 45 days. Schools have 45 days to respond to a FERPA to provide parents and eligible students with the opportunity to inspect and review education records within 45 days of the request. And I mentioned this a little later, but in most cases, the school does not have to provide actual copies. They have to facilitate an opportunity for the parent to come in and inspect the records. In some situations, if the parent can, make a strong case for some type of hardship where they can't come in, the most kind of clear example would be maybe the parent has a disability. It's very difficult, or transportation issue. They live in a rural area. It's very difficult for them to get into school, get to the school to inspect a record. In that case, the school might have an obligation to provide a copy. In most cases, the school just has an obligation to say, okay, hey, you could come in and you could look at this video footage of the act for which your student was disciplined, or look at this specific education record, whatever it is. Okay, Kelly's controlling the deck, so we're trying to kind of communicate by mental telepathy when I need her to move a slide, so it might take a minute in certain cases. Okay, so the U.S. Department of Ed's Student Privacy Policy Office, the SPPO, is the kind of sub-agency of the U.S. Department of Ed that's responsible for administering and enforcing FERPA. They often publish these guidance documents, and this is a big place where we find answers about FERPA, because the actual FERPA statute and the actual FERPA regulations are pretty terse. So this is where the office really kind of has these fact-based scenarios, and they provide guidance on FERPA. And they sent out a letter on the 28th that really kind of shows the office's kind of current view of FERPA. The first part is about kind of I guess you call kind of a culture wars issue. And I want to mention it just because I think it illustrates a couple of important points. Kelly, if you can go to the next slide. So this is on gender plans. So again, this is kind of a controversial culture wars issue. The point of the letter was a district in some state that's fallen under scrutiny was being their federal funding was being threatened to be withheld because they were withholding gender plans from parents. But it gets to a couple of important points here. So the letter says that gender plans are part of a student's education records. So if a parent requests to inspect and review their child's education records, the child's gender plan, if the child has one, must be included in those records. Related to this point, the letter clarifies that FERPA does not distinguish between a student's official school record and cumulative file. So this is what the school that was being charged with a FERPA violation was saying. They were saying, oh, that's not part of the education record. That's part of the cumulative file. We don't have to show the cumulative file to the parent. We only have to show the education record. The letter's saying there's no such thing. Everything is an education record. There's no kind of big file that the school keeps and then a smaller education record that they show to the parent. It's all one thing, and a gender plan has to be included with it, along with whatever else. Okay, Kelly, can you do the next one? Okay, but then this is the other kind of big point, or kind of not the big point of the letter, but kind of like the point I wanted to share with you all. At the same time, the guidance letter points out that FERPA does not provide an affirmative obligation for school officials to inform parents about any information. This is true even if that record is contained in a student's education record. FERPA requires that a school provide a parent with an opportunity to inspect and review the education records of their child upon request. So the school doesn't say, I have to say, hey, parents, we created this thing and this is in an education record. They just can't conceal it if the parent asks to review the education record, whether it's a gender plan or anything else. The school has no affirmative obligation to notify the parent that this thing is in the education record. Okay. And this letter was a two-parter. The other part was about student safety. And the letter asserts that schools should not withhold information from parents that identifies other students that have made death threats against their children. An example, student A writes a note or school assignment describing an intent or plan to kill student B. Okay, because the education record in question directly relates to both students, the parents of both students have a right to inspect and review that information. So that wouldn't be redacted. Student A's, you would show it to student B, student A's name would not be redacted on something like that. At the same time, the disciplinary sanction imposed on student A may not be shared with the parents of student B unless the sanction directly relates to both students, such as the details of a school safety plan. Nonetheless, school officials may inform student B's parents that responsive action is being taken with respect to the discipline of student A. Okay, so you could tell student B's parents, don't worry about it, we're handling it, we're disciplining student A. The parents said, well, what exact discipline are you giving him? Are you expelling him? Are you, doing this, that, or the other thing? You say, okay, we can't give you the specifics, just rest assured that disciplinary action is being taken. Okay, so switching gears to talk about standardized tests, where I feel like we're getting more and more questions about standardized tests. So here's a kind of lighthearted hypothetical after that, kind of scary hypothetical before that. Bryanstown Community Schools has devised its own standardized math test for placing students in advanced math beginning in the 5th grade. One student, the rather grandiosely named Pythagoras Nobel, took the test in 4th grade, but was not placed in advanced math for the 5th grade. Planning to have him retake the test, Pythagoras' parents have requested to view the test questions, asserting their right to inspect records under FERPA. Okay, so again, we look to, going through the archive of SPPO letters, they actually have a very helpful one about test instruments. Kelly, if you could click the next slide. Okay, this is the SPPO guidance on test instruments. I thought this was very interesting when I stumbled upon it. Test instruments are test booklets that do not identify a student or that do not contain personally identifiable information are not considered education records. In contrast, completed test instruments or question booklets containing information that identify a particular student constitute education records subject to the FERPA requirements. Okay, so imagine two different things. One is a booklet, the other is an answer sheet, or we used to call them scantrons when I was in high school. When I say that, people look at me like I'm nuts. I think bubble sheets maybe is what they call them now. So you think of those as two different things compared to one thing that's kind of one autonomous document that the student would record his or her name on, and would have both the questions and the student would mark their answers on that same document. Okay, Kelly, if you can click it. So therefore, in cases where an answer sheet is directly related to a student and is separate from the question booklet, not directly related to the student, only the answer sheet would be considered an education record, and thus you would have to allow the parent to inspect it. In cases where a question booklet includes both the questions and the student responses, the question booklet is an education record subject to FERPA. Okay, I hope that was clear. Okay, submitting a FERPA request. So this is the question of, can schools establish a procedure? And usually schools do kind of establish an ideal procedure, either in their policies or their annual FERPA notice, for how parents must request education records under FERPA. So this is something that is not addressed in the statute or the regulations. That is the mechanics of receiving and responding to an inspection request. Accordingly, a school may, I should have put that in italics, may choose to advise parents to submit a request in writing to the school principal or other appropriate school official. You can move on, Kelly. Okay, however, a school may not reject a parental request for review that is not submitted to the designated school official. Schools may only suggest to whom a parent should make a request to ensure maximum efficiency in processing. There's no provision in FERPA permitting districts to reject or refuse a request submitted to the wrong school official. Okay, so you can create a policy where FERPA requests have to be made to the school principal through the principal's secretary. That's kind of an ideal scenario. Nonetheless, you have to honor a FERPA request, even if it's made kind of in the wrong way. And then if a complaint is made that 45-day timeline was surpassed, then that really becomes kind of a fact-based analysis for the SPPO. When should that 45-day clock start? Maybe it doesn't start when the parent made the request to the lunch person, but maybe when the lunch person relayed that to the one of the student's teachers, that's when the clock should start, even though the teacher sat on that request and didn't get it to the school principal for kind of 2 months later. Okay, the right to seek amendment. This is one of the, I guess, I think kind of this is, of the big three rights, this is the one that maybe is, I don't know, the least understandable or the least dealt with. So FERPA grants parents the right to challenge the content and request amendment of education records the parent believes to be inaccurate, misleading, or otherwise in violation of the privacy rights of the student. Okay, first, the school only has the authority to amend a record created by the school. So if there's a transfer student, the school has no authority to amend a record created by the previous school. The SPP, kind of shifting gears slightly, the SPPO has clarified that parents may not use the FERPA amendment procedure to challenge a substantive decision made by a school district. Okay, so what is a substantive decision? In a 2006 guidance letter, the SPPO provides this example. The district expels a student for major misconduct, and this is recorded on the student's record. The parent challenges the suspension through the appropriate channel, and the discipline is changed to suspension for minor misconduct, yet the student's record is never updated. Parents may use FERPA to have the record amended, but not to challenge the suspension. So in another letter, SPPO says this right to seek amendment, really think of it in terms of changing errors in the record. there's an error in the record. You can't change kind of a major school decision based on kind of changing a grade or changing some type of disciplinary sanction. It's just changing kind of an error in the record. So after kind of that, you challenge a grade, the grade is changed, but it's never actually changed in the record. That's when the right to amendment kicks in. Okay, the right to consent, the last of the big three rights. So FERPA grants parents the right to consent to disclosure of personally identifiable information from education records. And it's important just to clarify, FERPA doesn't, in fact, grant any of these big three rights. They don't so much grant parents affirmative rights. Rather, the federal statute threatens to withhold federal funding from schools that do not kind of give parents these rights. Okay, and in particular, with the right to consent, this FERPA threatens to withhold federal funding from any educational agency or institution which has a policy or practice of releasing or providing access to any personally identifiable information in education records other than directory information, absent the student's parents' consent. Okay. So what is directory information? This includes the student's name, address, telephone listing, date and place of birth, participation in officially recognized activities and sports, weight and height of members of athletic teams, dates of attendance, awards received, and previous educational agency or institution attended. Okay, and then with directory information, the statute says any educational agency or institution making public directory information shall give public notice of the categories of information which is designated as such information with respect to each student's attending the institution or agency, and shall allow a reasonable period of time after such notice has been given for a parent to inform the institution or agency that any or all of the information designated should not be released without the parent's prior consent. Okay, so in your, I don't have a slide on the district's obligation to provide an annual FERPA notice. In that FERPA notice, you give parents, I believe, the requirements are, and I think there are among the requirements, you have to tell parents about those big three rights: the right to inspect education records, the right to seek amendment, the right to consent to personally identifiable information. You also have to inform the parent of their right to file a request or a complaint for a FERPA violation with the appropriate federal agency, the SPPO. But then here you also have to let them know what information you plan to release as directory information and give the parent a reasonable amount of time to, it says here, to tell the school that they can't release it without consenting, which is that would be a very strange scenario, that the parent says you can't release it without my consent, and then they give you their consent, right? This is really kind of an opt-out right. And that has to be in your annual FERPA notice, along with what from that list you are including as directory information. You don't have to include all that stuff, but that's the stuff that qualifies as directory information. Okay, and whenever a parent gives consent to the release of personally identifiable information in their student records, the consent has to be, for the consent to be legitimate, it has to include these things. The consent must be in writing. The consent must specify the records to be released. The consent must specify the reason for the release. The consent must specify to whom the records will be released. And a copy of the records released must also be provided to the parent if requested in the written consent. Okay, so again, typically the school does not have to provide copies of the education record. They just have to facilitate the parents coming in and inspecting the education record. But when a parent gives their written consent, if they request a kind of tangible copy, that must be provided in that scenario. Okay, and then there's some key important consent exceptions. There's a number of consent exceptions. Some of them are more, probably you're going to encounter them less. I think these are maybe some of the big ones. Okay, FERPA contains exceptions to the consent requirement for education records shared or released among school officials who have a legitimate educational interest in the records. To school officials at another school the student intends to enroll in, to appropriate persons in response to a health or safety emergency, and in response to a subpoena issued for a law enforcement purpose. That's in the statute. And Kelly, if you can click to the next slide. There's an important one in the regulations that applies to third parties, and this applies to kind of computer systems that the school would use. Okay, so how can a school put student information into a computer system? And this is really a software system, and this consent exception in the regulations is how schools have authority to do that. So the FERPA regulations extend the exception for records shared among school officials to agencies with which the school has outsourced institutional systems and functions, so long as the system performs an educational service or function for which the school would otherwise use employees. So if it's a kind of software system, it's still doing things that in the old days, school employees would actually do. Okay, is under the, this is a key, oh, Kelly, can you go back? This is a key one. Yep. Is under the direct control of the school with respect to the use and maintenance of education records, and pledges not to disclose the information to another outside party. So this is key when you have an agreement for a software system or with a third party. It's key that you bake in this language from the FERPA regulations into the agreement to make sure that you have authority under FERPA to share these records with a software system. Okay, and then our final hypothetical, and then I'm gonna pass it over to Kelly. We know that FERPA contains a consent exception for education records released in response to a subpoena issued for a law enforcement purpose. In a nearby district, 2 foreign exchange students from Hungary had an altercation last year. It was captured on video. So it's an education record because it relates to both of them. Both students have since returned to Budapest. A Hungarian prosecutor has reached out to the district requesting the video and records of the altercation. The prosecutor sent the records request through a formal letter written in both Hungarian and an authorized English translation with a fancy gold seal affixed, but not a subpoena or warrant. Should the district release the records? And the answer to that is no. Even if the letter seems very official, it's not a subpoena or a warrant, and thus the school should not release the records under FERPA. This is actually, there's kind of a dangling question here, is whether a foreign subpoena, schools should release records if so requested under a foreign, lawful foreign subpoena, but we're gonna table that one because we actually, myself and one of our clerks, we look for the answer for that and we cannot find it. So I think that's a case for the Supreme Court. So we'll table that, but that'll be a nice segue to Kelly's presentation.
Before we get started, Brian, you wanna leave a couple questions in the chat?
Sure.
Okay.
Yeah,
Should I answer them in the chat or?
No, let me read them to you. So can a parent request to review the video footage from an incident or an alleged incident?
Yeah. Okay. Again, so if the student is one, think of the student as one, if the student is one of the actors in that incident, whether to, I mean, the kind of the term perpetrator and victim are kind of loaded terms from criminal law, right? So let's think of if the student is one of the actors in that incident, whether the 2 kids are kind of scrapping and it's even, the one kid attacks the other, or what have you, then the parent has a right. It's part of the student's education record because it directly relates to the student, and either parent has a right under FERPA to view that. And that's also important for schools to preserve these records because these surveillance camera footage typically automatically erases. I don't know how it works at your school or at most schools, but at a certain number of dates, this footage typically erases. So if there is footage of an incident, to make sure that you preserve that. But again, general bystander footage where students are just walking by, Perhaps if a student is a witness and they record a witness statement, maybe that's part of their education record. But typically, bystander footage where the student is not an actor in that situation, that is not part of the student's education record, and that bystander student's parents does not have a right to view that footage.
All right, we have one more question. It looks like about a record request form. So it says we have a standard record request form. Is it advised that we have an area for the parent to indicate whether they want to review the records or if they'd like a copy? We verbally to get them to review the records, but they always end up wanting copies. And this is specific to 31N behavioral health services.
Yeah, again, you don't have, I mean, there's nothing in the FERPA statute that says you can't provide a copy. It just, there's nothing in it that says you must provide a copy. So I think, I mean, to create that goodwill with parents is always kind of, the ideal, right? So you don't want to look like you're hiding anything or that you're making it difficult for parents who assert a FERPA request. So there's nothing that says that you can't provide a copy. It just says that there's nothing that says that you do have to provide a copy. So if you don't want to provide a copy, in most situations, you don't have to. But if you do want to provide a copy and kind of create that goodwill, you have the right to.
All right, looks like that was the questions for FERPA. If you all have more questions, you can put them in the chat and Brian will keep an eye on it while we talk about subpoenas. All right, so if you receive a subpoena, what do you do next? That's the most common question I get. I get a phone call. We received this thing in the mail, or someone handed me something that looks like a subpoena. Now what do I do? It says I need to testify in 3 days. And I'll tell you something. The individual or the school officials that are most commonly subpoenaed to testify are principals. And I don't know if this is surprising to anyone. Maybe it's not. But I think part of the reason for that is because of your role, both with the students and the parents. You're in a unique position where you have a lot of information potentially. So we're going to be talking about testimony and some tips and tricks for you, or if some of your staff members, maybe employees, sometimes teachers get subpoenaed, but I would say more than 50% subpoenaed school officials are principals. So what do you do when someone hands you a subpoena? And we're going to talk a little bit about that. What's like initial steps? What are the first 4 things that you should do? Number 1, please do not set it on your desk and forget about it. Don't do that. Let your superintendent know immediately that you've received a subpoena. The second thing, notify your supervisor. Okay, so if that's your superintendent, if there's someone else that you would report to, assistant superintendent, let them know that you received a subpoena, because they are very time sensitive and there can be potentially very large consequences for failing to comply with the subpoena. The next thing you're going to do, and this will either be you or your superintendent, I've heard from both. Sometimes it's easier. They'll just say, hey, give Kelly at Thrun a call and talk through what this is going to look like. And then finally, stop the shredders, right? So if the subpoena is requesting records, whether that be education records or, as Brian talked about, videos, make sure you have the videos saved, because if we're going to have to turn information over, maybe video footage of a fight, maybe one parent suing another parent because their students got in a fight and a student got injured, we need to make sure that that video is saved. So those are the top 4 things that you're going to do immediately when you get a subpoena. All right. So I'm going to show you in a few slides what a subpoena looks like and exactly what you're going to be looking for. But these are the questions that I want you to think about. Number 1, who are the parties and is the district a party? So a subpoena will often say, John Smith versus Jane Doe, and you may recognize those names as parents because, let's be honest, most typically we receive subpoenas for custody disputes. And we're going to be talking a lot about those because schools are very, very often brought in the middle of custody disputes just by the nature of what we do and the fact that you spend so much time with their students, and you also have a lot of interaction as principals with the parents as well. So that's the most common type of subpoena you're probably going to see. So you're going to want to figure that out from the get-go, or is the school district named on the subpoena? Because if the school district is named on the subpoena, that's a whole nother ball game. Doesn't happen very often, but that's something your attorney is going to ask you right off the bat. And then the next thing you're going to want to ask is the subpoena for records or testimony or both? So I'll show you in a minute, but sometimes it just requests records and it says, please gather these records and send it to this attorney's email address by this date. Or sometimes it'll say, we're requesting principal so-and-so to testify on this day at this courthouse. So you're going to want to figure out which one it's requesting. And sometimes it may even say, we want you to bring these records with you to court to testify. Okay, so those are the three options. And then you're going to want to look at what's the due date for the request, or what's the court date, okay? Because if it's next week, you know, especially if it's for one of your teachers, I know this comes into play a lot, like finding subs, right, last minute. And we'll talk about timelines and how much time they actually have to give you. And for testimony, it's only 2 days. So you may need to figure out substitutes really quick. And we'll talk about a Zoom option. So as you can see on number 4, is testimony going to be in person or is it via Zoom? If it's in person and you or your teacher is on vacation, this happens often over the summer. Sometimes you're out of the country or whatever the case may be. That's when I come into play and I can say, hey, attorney, you know, so-and-so's out of the country, but we're more than willing to comply with the subpoena. Can we get a Zoom option? Like 90% of the time, the answer is yes, because people understand, number one, that it's a huge burden to put on school staff. And number two, in the summer, people who work at schools go on vacation, right? So, and there can be a number of other reasons to have a Zoom accommodation, but just know that that's an option, but you have to request it. You cannot assume that that's an option. And then finally, is the subpoena signed by a judge, clerk, or attorney of record? That's something that I can help identify for you. But once in a while, we have parents that aren't represented by attorneys, and they may find a form online that looks like a subpoena, and they may sign it themselves, or they may not sign it at all. And that's something to look for. Usually it's not bad intent. Sometimes it is, but there's something to look for whether or not we're actually complying with this subpoena. So this is what a subpoena actually looks like. This is an example of one. Obviously, you'll see on the top. Can you see my mouse, Brian? Perfect.
Mhm.
So on the top here, you're going to see a case number and you're going to see a judge. And this might look familiar to some of you, but this is typically what you can expect. Remember when we talked about looking at who the parties are? Right here, it'll say a party name. It'll say the defendant's name. So Jane Doe versus John Smith. Oh, John Smith. Oh, they sound like parents, right? So then you'll know, okay, this is probably custody, right? It's very common. And then down here, you're going to see a couple of options. So either you're going to be requested to appear personally at the time and place stated. So that's going to be when you're requested to testify in court. It's going to have the court name. It's going to have the address, the date, and the time. If it's for Zoom, it'll either have right here like a link to log on to the Zoom option, or it'll come with like a letter accompanying it, and that will have your logon information. More often than not, it's not automatically Zoom. Usually you have to request a Zoom option, but I've seen them that it's included there. And then that'll be testify will be checked here. And then if you see down here, you can do produce copies of the following items. That's going to be a records request, and they're probably going to put probably something that seems very, very broad. A lot of times we see these attorneys fill them out trying to get everything under the sun, but really all they want are attendance records for a couple of weeks. And so when we see a request that says all records for student A from the last 5 years involving XYZ, FG, like, whoa, hold up. And so that's something I can help you with, because I can reach out to that attorney and say, okay, I understand you're looking for information. I think you're looking for specific information. What exactly is that? Because I think a lot of times people who don't work with schools often don't realize how many records you have for students, billions. And sometimes they'll put communications related to the student. So all emails to, from, about student, that's thousands of emails, right? That's a lot. And usually they don't want all of those. So that's something I can help with in talking with them and figuring out, oh, you said all communications, but what you really want is a specific email sent from the principal to the student on this day, or whatever the case may be. Okay, and then we talked about looking to make sure that you have the attorney's signature and date. This is going to be the spot where it is down here. This is usually, if they're represented by an attorney, you're going to have the attorney name, phone number, address here. But this is what you're going to want to make sure that it doesn't have the parent's signature on it. So make sure and look in this little box here, and I can help you identify whether or not it's a clerk or a judge as well. Okay. I'm not going to go through all of these, but just so you know, these are what actually are required to be on a subpoena. So on the off chance that you get some document or form written, looks like a Word document that someone filled out saying they're subpoenaing records, that's not a subpoena. It needs to have just a number of items. Now, it might not look identical to the one that I showed you on the screen, but it should have all of these things, including like the date, the place where the trial hearing is scheduled. It needs to have a case number. That needs to have this warning that failure to obey may be subject the person to penalties for contempt of court. Okay, so service. So one of the important things with subpoenas is there's a required way that individuals need to serve the subpoena, meaning they need to deliver it to you in a certain way. All right. So it depends on who is being subpoenaed. Okay. So if the subpoena is addressed to the school, so the subpoena says, hey, school district, we want these records. In that case, it needs to be served on the board president, the secretary, the treasurer, or an officer having substantially similar duties. Okay, so you're going to want to identify exactly who they're subpoenaing. Is it the school? Is it records? Or is it an individual? Because if it's a principal, for example, then it needs to be served on the principal, not to a secretary, not to a board president, not to your teacher. It needs to be served on the principal. Okay, and it can be served either by hand delivery or certified mail. So when I say hand delivery, that just means they come into your building, somebody comes into your building with the document in their hand, and they say, you're being subpoenaed, here's the document. Okay, that's hand delivery. The other option is certified mail with a return receipt requested. So now come via the mail, and it'll be addressed to you. And that can come to your home address or the school's address. That either one's okay. So timelines. So this actually typically shocks people, but timeline for a subpoena for testimony is 2 days. And that's not a lot when you're running a school. That's not a lot when you have to find a substitute teacher with 2 days notice, but that's the law and it is what it is. So we have to roll with it. But once in a while, it'll give you 1 day, and then we can send a notice that we won't be complying with it. But 2 days for testimony, and then for records, it's 14 days, which is great. It gives you a little more time. I try to, whenever I speak with attorneys, I always tell them to give us as much time as possible, but 14 days. And that includes the scenario where you're required to come into court and testify and also bring records with you. Okay. So if the request is for records, what do? Well, first you figure out the due date and where and how to send the records. So a lot of times it's just sending via email to the attorney. Sometimes it's bringing them into court or delivering them to an attorney's office, but more times than not, they just want it via email. Then you're going to want to make a list of the requested records and who has access to them. Work with your IT to identify search terms, especially if they're looking for emails related to students. You're going to want to really narrow down the search terms to make sure that you're getting them the documents they requested. And this is probably similar to the process that you're using for FOIA, right? If you get a FOIA request for records, this is going to be similar to that. You're going to look for the records in a similar way. But a few things to look for specifically related to subpoenas when you're reviewing those records. You're going to look for, number one, attorney-client privileged. So that would be any privileged communication between your attorney and yourself or the school district. Okay, then you're going to look for student education records, and then finally a CPS documentation. So if you come across attorney-client privileged or CPS, just contact your counsel. If you haven't already, if you're feeling comfortable with subpoenas and you're like, I got this, but if you do come across attorney-client privilege or CPS, contact us, because we'll have to provide a privilege log and redact that information so that we're not waiving privilege. And then also the identity of any CPS reporter, is confidential under Michigan law. Sorry, I'm actually fighting a cold right now, so my voice isn't getting. And then if you come across student education records, FERPA actually requires you to send a notice to each and every student that's identified in those records. Well, if you get a subpoena for a bazillion documents, that could be a lot of students. So instead, what I tend to advise is, let's call the attorney and see if they want all this information related to these other students. 9 times out of 10, the answer is no. We just want information about this one student. And in that case, they say, go ahead and redact, and we redact, and we don't have to send out 100 notice letters to a bunch of parents that will have a bunch of questions. So this is typically the best route when you get a very large subpoena. And then finally, you're going to want to determine whether the teacher-student privilege applies. Now, this isn't like an actual legal term, but this is what we call it. So this is what it is. So there's actually a statute that requires parent consent or student consent if older than 18 before a school official provides testimony or records regarding the student's behavior, confidential communications, and confidential communications between the subpoenaed witness and the student. And this we call it the teacher-student privilege, but it applies to guidance counselors, school executives, so principals, applies to you, and anyone who is maintaining records of students' behavior or has records in their custody. So what does this mean? This means that when you get a subpoena for records related to your communications, or when you get a subpoena to testify in court, you actually need either parents' consent or the student's consent if over the age of 18. This is an example of a consent form we use. It just says, it's very simple. It just says, look, this law protects, this is your student. This is the case you want me to testify in. You're giving me consent to testify in this case and provide records in this case. And that consent is valid until it's withdrawn. Okay, so this is something we use. It's very simple, and it's just saying, hey, we're giving, Principal, Joe Smo, consent to testify about our student. 9 times out of 10, this is not very hard to get because a lot of times the subpoenas are from one parent on behalf of a student, right? So you just have to reach out to that parent and say, do you consent? They do, because they subpoenaed you. Once in a while, you'll run into a tricky situation where neither parent might be involved in the subpoena and they don't want to. In that case, I've got some tricks up my sleeve, but it doesn't happen often. So for purposes of today, we won't go into it. All right. And then we talked about this, the FERPA notice. So if you do get a subpoena, you don't have to get parents' consent, but you do have to give them reasonable notice that you're going to be providing those records. So if the attorney doesn't want you to redact the student names, you do have to give this notice. And the reason we're doing this is because it gives the parent an opportunity to go into the judge and say, hey, judge, so-and-so subpoenaing my student's records. I don't want him to these are privileged, these are confidential, whatever the case may be, and so that they can take action. Okay, so it's not a burden on us. It's just saying, hey, parent, if you want to take action, if you don't want these records released, then you can do something about it. Okay, so because you all are most commonly subpoenaed to testify, let's talk about some tips and tricks. So first of all, witness fees, you're gonna make bank, okay? Don't even worry about it when you get subpoenaed. You get $12 a day. That's at least one taco at Taco Bell. And $6 for a half day. So you'll have to get like just a Coke or something, I suppose. You also get mileage reimbursement if it's an in-person appearance. Obviously, if it's on Zoom, you don't get mileage reimbursement. And then the difference is, so if that person serves you personally, like hands the subpoena to you, then the witness fee and the mileage should be included at that time of service. So if someone does that and hands you a subpoena, you can say, where's the money, right? But if it's served via certified mail, in that case, they're going to give it to you at the courthouse or afterwards. They'll send you that big check. Don't spend it all in one place. Okay, so tip number 1, be there or be square. So always bring a copy of the subpoena with you because it has a bunch of important information on it. If you're actually going to the courthouse, make sure, and this seems obvious, like Kelly, I get it, leave time, but really like courthouses take time. You have to go through security. Parking's never easy. You have to find the courtroom. There's probably a lot of them unless you're in a small town. So make sure and leave enough time for that. And then check the courtroom rules. And that's so on the top of the subpoena, it'll say what courthouse you're going to and what courtroom. And you can look and see, are cell phones allowed? It's kind of a mixed bag on that these days, but if they are allowed in the courtroom, they should be off. They should not make any sound. And I will tell you the fear that you will feel if a judge stops the courtroom because your cell phone's going off. You do not want to feel that fear. It's not fun. And then for virtual, of course, find a quiet, confidential location. So if you're doing virtual from the school, I often recommend just finding a small office space or something where you can testify. Tip number 2 is mind your manners. So courtroom proceedings are formal. No socks and sandals, no shorts. Keep it professional. You don't have to wear a full suit, certainly. But maybe slacks and like a polo or like a blazer or something would look nice, especially if you're on Zoom. Sometimes people think virtual means you're good to go, but you should still look good from here up. And then if you hear a court official say all rise, you should stand if you're able. Like I said, generally no cell phones, food or drinks. Water might be allowed, but you're going to want to check that out before you go in. If you're testifying and you hear an attorney object, or if you hear a parent object or the judge start talking, you can just stop and then just wait, and someone will tell you when you can proceed. So they'll give you a lot of instructions when you're up there as to when you should be talking, when you shouldn't be talking. When in doubt, just stop, okay? And then this is something that people often get, and sometimes it's not very nice sounding when you're there, so I like to warn people ahead of time. Our natural inclination when answering questions sometimes is to say, like, did you see the sun out today? Well, a judge or an attorney is going to correct you, and they're going to say, please, yes or no, right? And it may come off a little bit harsh. It's not intended to. It's just for the court record. So you're going to want to make sure and use the yes, the no, maybe, but no mm-hms. Okay, tip number 3. Take your time, okay? Make sure you understand the question before you answer. If you don't understand the question, just ask the attorney to repeat. People do that all the time. Sometimes attorneys get going or they're talking fast or don't understand what you're asking. Don't feel like you need to make something up. Just say, can you please repeat the question? And then this is a big one. This is, I think, what people struggle with, because I think people generally have really goodwill and they want to provide all the information that they have, which is good. and, honorable. The thing is, when you're in court, you should only answer the question that's asked. So an example, did you see, what color is the sky? Well, blue. The answer should be blue. Your answer should not be, it's blue, but there were clouds and it looks like it was gonna rain yesterday. Oh, and also, I don't know, it kind of looks like it's getting darker outside. You see what I mean? Don't go on and on. I know that it's an instinct to be honest and truthful and to provide information, but really, if the question is, what color is the sky? It's blue, period, end, and stop talking. So this is a hard one, but and the first time you testify, it'll probably happen to you. That's okay, but it's something to be mindful of. And that it goes with the second, right? Don't volunteer additional information and remain neutral, because a lot of times you're going to be talking about probably two parents, and you work with the student and you work with both parents, and they might be asking you questions, opinion questions, which we'll talk about in just a second. And you are neutral. You are here for the student. You are here for the student's success and the student's education, and you are neutral as to what parent should have custody, right? So that's a big one. Okay, 2 more tips and then I'll be done here. I don't see any questions coming in through the chat, so if you have questions, let me know. Tip number 4, it's okay to say, I don't know. Don't feel like you need to make something up or guess or speculate. Only testify to your personal knowledge. So as it relates to custody, this is a big one. It shouldn't happen. Neither attorney should ask you, well, what parent should have custody, or what parent is better fit to have custody of the student or bring the student to school, or whatever the case may be. They shouldn't ask you that. But if they do, you are what's called a lay witness, and that means you're only testifying as to your personal knowledge. So if that happens, you can respond with, number 1, I am not an expert in child welfare. Number 2, I have limited knowledge of the parent and student's interactions outside of school. And number 3, I can only testify as to my personal knowledge of what I'm observing in school. And then answer the question. Okay, in school, I observed that student is doing this. Okay, so it's kind of a skirt around, but it's really signaling to them, we're remaining neutral. We don't know what your home life is like. We see what's happening at school, and that's it. So that's a good answer I like to give people, because it does happen. It shouldn't happen, but it does. And then finally, keep calm. Don't let attorneys put words in your mouth, and listen carefully to how your testimony is being rephrased. So sometimes attorneys will kind of mirror back what you said. Oh, well, you said this. Is that right? Make sure when they do that, they're accurately saying what you said. Okay, so listen carefully, take a breath. Watch out for words like only, never, always. If something is typically true or sometimes true, you can say that and then say, but there are exceptions, right? So just don't be afraid to say what's actually truth. You don't need to use only, ever, always. Say what you observe, and that's all you're required to do. And then you are allowed to say that you spoke with your attorney, but I wouldn't give details because that's covered by attorney-client privilege. All right. Oh, number 6, tell the truth. Yes, lying is perjury, and could carry criminal penalties. Don't do it. And failure to comply. Okay, so if you don't provide the records, if you don't show up to testify, you could be held in contempt of court. That's why we don't ignore them. Always give it to your superintendent, call your attorney, however your process is at your school. Why? Because you could get a misdemeanor up to 93 days and a $7,500 fine. All right. Any questions?
I am not seeing any in the Q&A, but we are just about at the end of our time. So if you do have a question, go ahead and pop one in there real quick. I actually did have a question, Kelly. As you were going through the subpoena, I did notice there was a spot where, as they are requesting records, and sometimes, as you mentioned, they make it sound like they want all of these things, and really they're hinting at this very specific, more narrowly focused, request, that that there is a fee that they would have to pay to get those records. Did I see that correctly on the subpoena form? Like they'd have to pay for those records for a school to run all those copies. Is there any sort of like, is that typically like a standard rate? Is that really based on the scope of the request and how much work is being put in that? Have you ever seen where people are trying to, put an exorbitant amount of cost on that? Say, oh, this would be $10,000 for these 100 pages, or just any sort of insight into that piece that you can provide?
Well, actually, I do see that it's on there, but technically speaking, they never charge, and you never get to charge for subpoenaed records. If they ask for a ridiculous amount of records and they ask for copies of those records, we could file a motion to quash. I could speak with the attorney, but the only fee you're going to be receiving for a subpoena, unfortunately, is just that large fee for testimony.
Gotcha. That makes sense. I know, and for like FOIA, typically I know a lot of districts have a fee or a set rate or whatever it is. So I was curious if that was similar. So thank you.
And so sometimes instead of FOIAing, they may submit a subpoena so that they don't have to
get
pay.
around the makes sense. All right.
Yeah.
All right. Well, I am not seeing any questions. So great job. That means you explained it thoroughly and everyone got their question answered as you were both presenting. So Brian and Kelly, thank you so much for taking the time to be with us today, covering managing information requests. Again, once more to everybody on the webinar, we will send out a slide deck as well as a copy of the recording. Just give me a couple of days to do that, please. We will get it to you. Otherwise, make sure you check massp.com/events. We have other legal webinars and webinars on other topics coming up from now and through December. So make sure you go onto the website and register for those. And we'll see everyone at a future webinar. Thanks, everybody.